Welcome to the Legal Innovation series. My name is Maurus Schreyvogel. I'm the Chief Legal Innovation Officer at Novartis, and today I want to speak to you about Rightsourcing. What is hiding behind that term is very simple. It's trying to find the right source for a specific activity. As we are speaking about who, that oftentimes goes together with how. So when we're speaking about Rightsourcing today, I want to look at this in the most holistic way possible and speak to you about 3 examples where a legal team, a legal function has reimagined their sourcing model, mostly to overcome an urgent need, a necessity, in order to optimally support the organization within they were active. So let's get started right away. The first 2 examples are big examples, and I will not go very deep, but it is both of those examples are interesting examples for you to provide further research about. The third is an example that I've been involved by myself, and I go there a little bit deeper, but I think the principle of the third example applies to the first 2 as well. I want to start speaking to you about eBay, which is one of the most prominent examples of reimagine how they sourced the legal team that is supporting the traders that use the eBay platform. eBay is faced with the issue that they have to administrate, manage, or resolve 60 million conflicts that arise out of eBay transactions. And eBay responded to this issue by putting in place an online dispute resolution service, which is sourced by automation, by process excellence, and by a small team of legal professionals who help bringing those 60 million conflicts to a hopefully positive outcome. I've chosen this example because here the legal function of eBay is playing a core role to enable the eBay business model, because dispute resolution, certainly for heavy traders, is very likely a killer argument for choosing a trading platform versus another. And the eBay team, the eBay legal team, couldn't have achieved managing this amount. And keep in mind, it's a mind-blowing number of 60 million disputes that they have to clear every year, without putting a sourcing mix in place that is cost-effective, that is quick, and that leads to fair outcomes, keeping in mind that most of those disputes are in the low dollar amount, or those disputes arise out of the same or similar situations all the time. This is why I've chosen this example, where I think a legal team is managing the front line of the customer interactions of in the meantime, large and important player on the market. Moving on, I want to speak to you about a slightly different, but still an online example. For those who are not familiar with FlightRide, this is a platform that is solving a consumer problem. We've all been in the situation that a flight is delayed, that a flight might be cancelled, and we need to find either we get stranded or we need to find an alternative means of transportation in order to get to our destination or to get home. In Europe, we are not only entitled for a financial benefit for making our plans or our alternative plans, but we also are entitled to a compensation, which is measured by the time that we are losing due to a flight delay or to a flight cancellation. These claims for this compensation are really complicated to enforce if you're doing this on our own. The airlines can play time if we do it by ourselves. If we are engaging an attorney, oftentimes the cost of the attorneys will very likely outweigh the benefit, which is, according to FlightRide, between, depending on how many hours or many minutes we lost, between 100 and 250 euros per person. So what FlightRide did is providing a very simple interface where we can enter our information about the delay or cancellation, and FlightRide, on the basis of prior cases, is calculating whether we are entitled for a compensation. On that basis, we can delegate to FlightRide our case, and FlightRide will fight on our behalf this claim for compensation. Naturally, FlightRide doesn't enter into a dispute for every case, but they collect cases, and on regular basis they're sitting down with the major airlines to figure out a fair closure to this conflict, and at the end of the process the consumer is receiving the compensation amount, minus, of course, a service fee that FlightRide is charging in order to pay for their resources. FlightRide again reimagined the source of legal power that they put against this problem. It's a very narrow legal service that they provide, but they excelled in finding the right sourcing mix in order to respond to this problem, so that they can not only ensure that the compensation is reaching the end consumer, but they're also making a profit for themselves on the go. Small team, powerful technology and a great process landscape enables FlightRide to have established themselves in the market a couple of years ago, and since then they've been reimbursing 300 million euros to European customers for flight delays and cancellation. From my perspective, a great service which was possible because they were thinking outside of the box as to how legal services could be applied to one specific problem. Now, we've looked at two examples of sourcing mixes that were an integrated component of a business model. I will now change into looking at a more traditional setup, but I ask you to keep in mind what we've just heard about eBay and FlightRide, because I think those two examples are very relevant when we think about the setup, about the service delivery model of our own legal function. So, as I mentioned at the beginning, I'm working for and with the legal group at Novartis, and in 2018 we recognized a problem that you could refer to as a burning platform. We've been at a juncture, at a point where we realized that between 2018 and 2025, we have an unprecedented amount of product launches that will require a lot of legal support in order for those product launches to be supported and for those product launches to go smoothly. Some of those product launches were even or are even in disease areas new to Novartis, which means even more or an even heavier burden for the legal departments to counsel and to support the product teams to optimally launch their products in the respective markets. As we all know, it is hard to compete for additional resources, and given that the Novartis legal team in the pharma benchmarks is more or less midfield, we thought we were not even going to try to compete or to ask for additional resources, but we were trying to see whether we can tweak the way we use our existing resources in order to respond to this demand, to this legal demand that arose out of these numerous product launches, which by now we are in the middle of. So what did we do? We've decided that we will conduct an activity assessment first in order to better understand the utilization, the current utilization in 2018 of our attorneys. We started off by presenting to our legal function a strategy, a sourcing strategy that we've kicked off with an activity survey that we've asked our legal team to complete. we've asked our legal team to estimate, on the basis of the last 12 months, the percentage of work that they invested in specific legal verticals, sub-verticals, and activities. We made sure that our legal professionals understood the purpose of this activity. We ensured that people understood that the purpose of the survey, the purpose of this entire initiative, was to adjust our sourcing mix to better respond to the increasing legal demand towards the legal function. That this activity survey has nothing to do with cost cutting or reducing legal staff. Once we've established that, we sent out a survey to the entire legal function, to all legal professionals, asking them, as I said before, to estimate what they have done during the last 12 months. People would then complete the survey suggesting that they spend 20% on litigation, maybe 10% of those 20% were in product liability, the other 10% were on general litigation, and we then went one step further and asked them for product liability, what exactly did you focus on? The answer could have been pre-trial activities or electronic discovery and so on. We were very surprised to learn about the outcome of this survey in terms of participation. Given that people understood the purpose of why we're doing this, we've had a nearly 100% response rate, which was a first for us in communicating with our function through a survey. But this output or this return has just proven to us that our people understood the importance of that survey in order to continue to provide an outstanding legal service to our company and to the patients that benefit from the services of our company. Good. So we've received a massive amount of data, which all boil down to understanding the activity of our function. What we did next was we were trying to group those activities on a matrix that had two axes. We've looked at every activity and we tried to figure out what is the risk relevance and the strategic importance of such an activity. And then we placed it on the matrix that you see on the left-hand side of this slide. We've done, probably we had 700-800 activities that we plotted, which means we didn't just look at contract drafting. We've looked at contract drafting in a specific legal area. So contract drafting for an M&A transaction was on a different post-it than contract drafting for a non-disclosure agreement. So within a relatively small team of 25 people, we've completed on the basis of unique activities that matrix, where we went from kind of where the axes meet, low strategic importance and low risk relevance, two activities where you see the light bulb of high strategic importance and high risk relevance. The outcome of this activity informed us about how many people were involved in what types of activities. And we were then starting to develop for each of those quadrants a sourcing strategy and a service delivery strategy, which I will present to you next. What you see is specific, of course, to the needs of our own company, and then the sourcing or service delivery strategy could look quite different for your own company. But important is that we felt, for our purposes, grouping our activities in those two categories that I'm presenting was well understood, pretty straightforward, and easy to do. Good. Moving on, the sourcing model that we've developed on that basis, and I'll ask you to focus on the middle part of the right portion of the screen, is we felt that these four quadrants can be reflected in the four big groupings that you see here in the middle, starting with no risk relevance and no strategic importance, where we were trying to find automation. If we go into a little bit of risk or slightly strategic relevance, we went for managed services, where you go up into either higher risk or higher strategic importance. We went into matter type specialist delivered services, and where it goes in direction bet to company activity, we kept kind of the strategic advisor approach, which is the traditional service delivery approach that we've had before performing this activity. So those four rectangles that you see here correspond to the four buckets that you see on the risk strategic matrix that we've used. I mentioned in the beginning that we cannot just look at who, but we should be looking at who and how, which is why, or which is where we developed this model, which splits up the legal activities in 3 phases, 4 delivery schemes, and 2 performance management measures. Taking you through those next. We introduced a work intake, which is what you can see on the left-hand side. A front door for our business partners when they bring work into the legal department, where we make a conscious decision as to what service delivery model is optimally suited in order to address a specific problem. This, by the way, is something that doesn't mean that our business partners can no longer speak to us. We are just having a standardized intake methodology that either responds to a service request that we receive online, that responds to a phone call that we receive, and where we do the data entry thereafter. But what we have in common now is that we have this consistent triaging process that leads to an allocation to one of those full service delivery models. We're not always getting this right. This is not exact science. Oftentimes an activity jumps through the service delivery methodologies, but that's perfectly okay as long as we are collecting data in the background to better understand how a specific problem has been successfully matched to a delivery model, so that we can do resource planning for the future. The two rectangles in the bottom end of the delivery scheme we didn't have consistently in the past, and this is what we are building up within our legal department to leverage automation, not just for specific services in a specific country, but doing so at global scale. The same goes for managed services, which we've decided for our purposes to partially source externally and partially source internally through our services centers. And if you go to the top two rectangles, we've put in a split between legal subject matter experts in the dark blue and legal generalists that mostly support the management teams at global division levels or at the country levels, which is the way the Novartis organization is structured. Lastly, in terms of performance management, we believe that what you see here at the bottom in the gray area needs to be managed and measured differently than what you have in the white area, where we should have a focus on innovation and where we should ensure that the legal resources that are taking care of those items are being given the freedom to innovate, versus if we think about contract creation, contract negotiation, there we should be focusing on things like cycle time, adherence to standards, and understanding or ensuring that our contracting language optimally suits the needs of Novartis, but also is well suited for Novartis to be active in a specific marketplace. If our legal, if our contracting language is not being accepted in a given marketplace, we believe we haven't done a good job. Which means we need to adjust our contracting language in order for our contracts to be a business enabler and ensuring that we appear on the market as reasonable partner. Finally, we do a closeout phase, ensuring that we are receiving enough feedback in order to improve our intake process and in order for us to understand that we're properly resourced, that we have the right capabilities, that we have the right processes and the right technology in those four service or supporting those full service delivery schemes. Good. This, as I said, is something that we've developed on the basis of our activity assessment. This seems to be working well for us. It could look quite differently for other companies, depending on the demand towards the legal function. So this isn't meant to be a general guidance. It's rather the process that we went through in order to develop this service delivery model, which I thought would be an interesting piece of information, hopefully, for all of you. In closing out, I just want to make sure that we're not just focusing on, you know, working from A to B, but that we are thinking a little bit further than just the immediate benefit of such a model. And here I want to start by suggesting that the adjustment of our service delivery yielded more satisfied lawyers within our legal department. Because with this model, we were able to reduce the work activities that you would consider routine activities by putting technology in place for our lawyers, for our legal professionals in general, to be focusing on what they were trained for, which is legal judgment. We believe that we've also changed the concept from just being overwhelmed with work that comes in, that everyone triages by themselves, by giving our legal professionals a generally accepted way to triage the intake of legal services, helping them to prioritize the type of work that is they're being exposed to. Secondly, be this through automation or just through optimized performance management, we have happier customers or business partners, however you want to call the people that represent other functions in the enterprise, because they get access to legal services faster, more consistent, and given the global harmonization of our services, legal services become simpler to understand. Finally, looking at costs, and this has never been a core focus of ours, but what I've mentioned before is naturally optimizing the cost base of the legal function, because we're driving down to automation activities that can be automated or activities that can be standardized, which on the other end frees up attorney time in order to be readily available for the more complicated demands that require legal judgment, which again reduces our need to seek support from outside counsel just for capacity reasons. We still go and we still believe that outside counsel is of tremendous value to us as a benchmarking partner, or for specific subject matter expertise that we don't have in-house, that we don't think we need to have in-house. But again, it becomes very clear what is the situation where an in-house counsel will be collaborating with an outside counsel, and it is no longer a just a pure function of us being overworked, that we're giving pieces of work to outside counsel that eventually would have been dealt with more effectively in-house, given the institutional knowledge, for example, that our legal professionals possess. Super. That was a very fast journey through our process of reimagining how we provide legal services. I invite all of you to enter into a conversation with me. I'm leaving here my email address. Please use it if you'd like to trade experiences, or learn a little bit more about our journey. I'd be happy to speak with all of you, and we'll leave you today by wishing you a fantastic rest of the day, and thank you very much for listening to me. Thank you.